Right, hello everybody. My name is Zorana Todorović, and I will talk about animal rights, legal rights, and not moral rights. I will discuss two different strategies for securing legal rights for animals: recognition of their social membership and their membership rights based on their co-membership of a shared society, and on the other hand, recognition of rights that animals already have implicitly, which are protected by the existing animal welfare laws and which could be based on the 5 freedoms. I will argue that these rights, which are sometimes called welfare rights, so I will use this term too, need to be further specified and legally recognized and turned into actual legal rights. When it comes to membership-based rights, proponents of the social recognition strategy, like Will Kimlicka and Sue Donaldson, argue that in addition to natural duties we may owe to all sentient animals based on their having moral status, we have special duties to domesticated animals that are members of our societies. Domesticated animals, or DAs for short, include companion animals, CAs, farmed animals, and research or lab animals. It is argued that domesticated animals need to be recognized as co-members of a shared human-animal society with membership rights. Specifically, companion animals should be recognized as family members with family rights, and farmed and lab animals as workers or co-workers with labor rights. Yeah. Okay. Many scholars and citizens as well argue for legal reforms that would recognize that companion animals are unique family members and not replaceable property they are considered to be now, when legal decisions about them are based on ownership principles. It is argued that companion animals need to be recognized as co-members of the family with membership-based interests and rights. Kimlicka argues that this recognition of companion animals as members of private families need to be extended beyond animals such as cats and dogs to all domesticated animals such as farmed animals and some lab animals too, that should be recognized as members of the broader society with rights to public goods and public services. Now, animals work with and for people and can be seen as their co-workers in a number of workplaces: on farms, in laboratories, hospitals, senior homes, military, police, etc. And they can be said to have jobs or formal occupations, whether full-time or part-time. Thus, they could be legally defined and recognized as co-workers based on their membership in a shared interspecies workplace. It is argued that they should have workers' or labor rights, such as the right to healthy and safe working conditions, the right to maximum working hours, the right to rest and leisure, the right to retirement, etc. Kendra Coulter believes that a set of labor rights could be identified in most or all contexts, and that animal labor law could be useful. It was really human workers who demanded legal recognition of animals as their co-workers. And there are already examples of animals recognized as personnel rather than property or equipment they used to be categorized as. These are, for example, police dogs in the British police force with the right to state pension, military dogs in the US Army that have the right to rehoming after retirement and repatriation, and so on. Kimlicka argues that this recognition of animals as co-workers could be gradually extended to other contexts and other kinds of animals, such as farmed animals and lab animals. Now, according to this view, membership-based or relational rights take into account various types of relationships we have with them and various duties we have to these animals. But it can be argued that this is not the best way to determine animals' legal rights. Group membership does not seem to be morally relevant. Morally relevant differences between or among animals are not based on their membership of different groups within human society, but on their capacities and interests that arise from them that are morally relevant, such as the capacity to feel pain and pleasure or sentience, and the interest that arises from it in not feeling pain or in not suffering. Cochrane argues that, quote, the rights of any particular animal are better determined via a cosmopolitan perspective that attaches rights to individuals primarily according to their capacities and interests as opposed to their membership in different groups. Also, membership-based rights seem feasible mostly for some categories of animals, such as service animals, police, military animals, therapy animals, possible for companion animals too, but not so much for farmed animals and lab animals. Still, Cochrane points out that membership is crucial for protecting core animal interests, and that one of the core animal interests is in being recognized as a member of the community whose interests count. Thus, he advocates recognizing working animals as co-workers and productive members of the society whose core interests in not suffering, in continued living, and in being recognized as a productive member of the society are respected and protected by a set of labor rights. I believe that recognition of animals' membership-based or relational rights makes sense because we tend to think about animals in terms of our relationship with them and their place or role within our society. We treat quite differently animals with comparable capacities depending on our relationship with them and their group membership. And for example, we provide gentle care for our beloved pets, such as dogs, while animals with similar capacities or even more developed capacities, such as pigs, are raised to be eaten and often live in appalling conditions. And to conclude this part of my talk, I believe that the social recognition strategy is well worth pursuing and that efforts should be made to secure positive social rights for animals. But like I said before, this strategy seems likely mostly for some categories of animals, and so I would suggest another strategy that is, in my view, simpler and more feasible, which is to recognize rights that animals already have implicitly, which are protected by the existing animal welfare laws and legal regulations that are already in place. These rights are sometimes called, like I said, can be called welfare rights. According to the interest-based conception of rights, legal rights are in fact legally protected interests, so sentient animals as interest holders are potential right holders. Existing animal welfare laws already treat animals as holders of some morally and legally relevant interests, which are grounds of legal protections that are granted to sentient animals by animal welfare laws, or legal duties imposed on people to protect animals. These legal protections can be seen as implicit animal rights, which correlate with duties that people have to protect animals. Visa Kurki argues that these protections, which can be derived from the existing animal welfare laws and which are granted to sentient animals, can be classified as rights under the interest theory, and that animals already hold a number of claim rights relating to their treatment. However, these rights are implicit, and they are not recognized in practice as actual explicit legal rights, and so they do not protect animals in the way legal rights usually do. Saskia Stucki points out that current unwritten animal rights provide only a weak form of legal protection that is not typical of legal rights. She argues that animal welfare rights are weak, imperfect, simple rights, but that they have the potential to become stronger fundamental legal rights that would protect animals' fundamental interests. And so I argue that these implicit animal welfare rights need to be explicitly recognized and turned into actual legal rights. And if they were to be further specified and legally recognized, they would no longer be weak rights. These rights could be based on the 5 freedoms, which are minimum welfare standards that apply to farm animals and are the bedrock of the existing European animal welfare laws. The principle of 5 freedoms has been conceived in Britain in the 1960s and revised, improved in the late 1970s as minimum welfare standards that should be met to ensure the welfare of farm animals. These freedoms include freedom from hunger, thirst, and malnutrition, freedom from discomfort, freedom from pain, injury, and disease, freedom to express normal behavior, freedom from fear and distress. These 5 freedoms can be said to protect or cover the basic animal interest in not suffering or in not being harmed. Now, many argue that the 5 freedoms are obsolete and should be dropped because they do not really protect the welfare of animals. And although I agree that these welfare standards, as well as the existing animal welfare laws that are based on them, are not effective enough in protecting animals' welfare, let alone their interests, I believe that their use should not be discontinued, but that they need to be further specified and turned into actual legal rights. This path has been suggested by some scholars who argue that the 5 freedoms can be understood as minimum rights that apply to animals or can be reformulated as rights, and it would look like this. And this reformulation is from Angela Martin's paper. Right to be free from hunger and thirst, right to be free from discomfort, right to be free from pain, injury, and disease, right to be free to express normal behavior, right to be free from fear and distress. Reformulated in this way, the 5 freedoms can provide a blueprint for conceptualizing specific animal rights, which, if legally recognized, would protect basic animal interests in not suffering and in being treated well. These explicit animal welfare rights could include the right not to be harmed or not to suffer, the right to be cared for or to well-being, the right to have adequate living space, and other conditions peculiar to their species, and so on. This list of rights is provisional. It's my take on how to translate the 5 freedoms and legal protections derived from the existing animal welfare laws in such a way that they're not simply reformulated as rights. These rights could be seen as claim rights in that they would correlate with direct duties of people to animals as right holders, such as the duty not to harm them, to provide care, and to provide adequate conditions. Like Saskia Stucki points out, claim rights are passive rights that imply legal duties of others towards animals, and they're not exercised but enjoyed by the right holder, and thus they're suitable for animals. These welfare rights would protect basic interests of animals, like the interest in not suffering or avoiding physical and mental suffering, and interest in being treated well, especially in not being harmed, which are the most basic interests of domesticated animals and all other sentient animals that have the interest in their experiential well-being. Obviously, these rights, even when explicitly recognized as legal rights, would not protect some of animals' fundamental interests, like the interest in life and freedom. But they could in time be supplemented with some other rights, like the right to continued existence or living, which would protect their fundamental interest in staying alive. And they could potentially develop to become fundamental legal rights, which would protect animals' most fundamental interests. These welfare rights are broader in scope than membership-based rights that apply only to a specific group of animals. Unlike them, welfare rights could be applied to all sentient animals whose welfare depends on humans who have duties to protect them and care for them, such as farm animals, companion animals, research animals, animals in zoos and entertainment industry, and they could possibly apply to some wild animals too, especially the right not to be harmed. I believe that legal recognition of these rights is the best strategy we have at the moment for getting a foot in the door, or rather a paw. And taking baby steps is, in my opinion, the best way to advance the protection of animals' welfare and interests. Then, in addition to these welfare rights that will protect their most basic interests, some positive social rights, like membership rights, could be demanded for specific groups of animals. And finally, I believe that these two strategies are not alternatives or mutually exclusive, but they rather complement each other. And here are some of the sources I used. Thank you for your attention.